Good morning, ladies and gentlemen, and welcome to Fenchurch Law's first public webinar of 2022. My name's David Price, and I'm a partner in the construction risks team at Fenchurch Law. And it's fair to say that we've never had as many sign-ups for one of our construction risks webinars before today. And I'd love to think that you are here to listen to my dulcet tones, but I know that that's not actually the truth, and that the star of the show today is undoubtedly the cheeky little exclusions we're going to be talking about. We're going to be talking about defects exclusions in constructional risks policies. So what is so fascinating about these clauses? Everyone that works with defects exclusions, I would say, even if we haven't memorized the exact words of each of the exclusions, we know basically what each of them says. And I think also we probably know what each of the clauses means, at least in general terms, and when we are thinking about those clauses in the abstract. But where it gets interesting is when you begin to apply each of the clauses in real life situations. And the way I like to think about the defects exclusions is a little bit like Lyra's alethiometer in Philip Pullman's Dark Materials novels. So there are layers of meaning here. So you have a surface layer where you're looking at what the exclusions say, and in general terms, what they mean. And then as you work more and more with each of the exclusions, you begin to find deeper layers of meaning in relation to each of them. And unpacking the exclusions requires looking at a variety of different and related concepts. And if you listen to any talk on defects exclusions, the speaker's always going to have a choice. And for me, the main choice is about the degree of magnification, and that's always going to be a personal choice. And where I have chosen to focus today is a series of issues which, in my view, are going to be of practical benefit to brokers and contractors. So what I'm not going to do is I'm not going to go slavishly through each of the 5 DE clauses, each of the 3 leg clauses, explain to you what every single word in each of the clauses means. Equally, what I'm not going to do is I'm not going to do a super deep dive in relation to any of the issues which I'm going to be touching on today. What instead I'm going to do is try and give an overall understanding about the clauses and how they fit together, and explain what I regard as being the most significant issues that typically come up in practice in relation to each of the clauses. And I'm going to give some suggestions for how you can navigate those issues when they arise for you in practice. A couple of housekeeping points just to begin with. I'm going to leave time for questions at the end. The way to ask questions is via the Q&A box, which you should see on your screen, or if you don't see it on your screen, then hovering over the top of the screen or the right-hand side of the screen should bring it up. There will be copies of the slides and a copy of this recording that will be sent to you this afternoon. And along with the slides and the recording is going to be a feedback survey. And it's super important to us that you complete the feedback survey if you have time to do so. And what we're really interested in more than anything else is for you to tell us what subjects you would like us to talk about in the future. If there is anything to do with insurance disputes that you would like us to look at from a pro policyholder perspective, then please tell us and we will put something on for you. So I'm just trying to click onto the next slide and had my first technical failure. Let's see, I'll use the cursors. Apologies, bear with me just one second. There we go. Right, so what's on the agenda today? Thank you very much, Michael, for fixing that. So on the agenda for today is talking about car insurance, what it is and what's the relevance of the defects exclusions. Then going to talk about some groups of defects exclusions. I'll be talking about the exclusions together. So I'm going to start off by talking about DE1 and DE2 and leg 1. Then I'm going to go on to D3 and D4. Then I'm going to deal with leg 2 separately. And I'm going to finish off by looking at DE5 and leg 3. Now, when you're looking at defects exclusions, you are looking at a series of standard form exclusions which are of increasing benefit to the policyholder as you go through the suite of exclusions. So as the number of the exclusion gets higher, you are getting an increasingly favourable clause as far as the policyholder is concerned. So you start with D1 and Leg 1, you have clauses which are unfavourable to the policyholder and exclude a very great deal. And as you get to D5 and Leg 3, you have clauses which are much more favourable. So I would also suggest that you look at the clauses in terms of there being two groups. And the first group is the clauses that have a focus on saying what is it that is excluded. And those clauses are D1 to D4 and Leg 1. And then you have a group of clauses where the primary focus is on the right back. So you have an explanation at the start of the clause of what is excluded, but really the real action is in relation to what the right back covers. And falling into that category, you've got Leg 2, D5, and Leg 3. So to put this into context, what are we looking at here? We're looking at a very specific kind of insurance policy. We are looking at a construction all risks policy. And with an all risks policy, the scope of the cover is determined not by a list of specified perils. It is going to be determined by the exclusions in the policy. All risks of what? Well, this isn't covering all different risks that a contractor might face in their business. This is covering a very specific kind of risk, and it's the risk of damage. There is no cover for fixing property that is just defective, and that's something that I'm going to come back to in a little bit of detail as I go through the talk. So what is damage? Damage is something that requires you to satisfy three different elements of a test. First of all, there has to be a change in physical condition. That change must be unwanted from the point of view of the owner of the relevant property, and the change impairs value or usefulness. So I'll just recap on that briefly, as it's going to be pretty central to a lot of things I'm going to be talking about today. Damage is a change in physical condition which is unwanted from the point of view of the owner of the relevant property, and that impairs value or usefulness. And what kind of damage is insured? We're not talking about damage to anything here. No, we're just talking about a specific kind of property which will trigger the policy if it becomes damaged, and that is damage to contract works. And that includes both permanent works and temporary works. So we come to defects exclusions. I've said that the scope of an all risk policy is determined primarily by the exclusions, and I would suggest that the most significant exclusions that you are going to need to grapple with in a construction all risks policy are going to be the defects exclusions. Now, it is true that bespoke defects exclusions do exist, but the overwhelming majority of construction all risks policies contain standard defects exclusions, and for today I'm only going to be focusing on those standard exclusions. And there are two separate suites of defects exclusions which you will commonly come across. You have the DE exclusions, which stands for defects exclusions, and you have a suite of 5 exclusions, and then you have a second set of defects exclusions which are known as the LEG exclusions, and LEG stands for the London Engineering Group, and you have a suite of 3 LEG exclusions. It's quite often the case that in construction all risks policies, the policyholder is given a choice of which defect exclusion they would like to apply to a particular loss. So, for instance, the defects exclusion, which is generally regarded as being the standard defects exclusion and the most common one to have in a construction all risks policy, would be DE3. And DE3 excludes damage to any property that was in a defective condition before the damage occurred. And you generally would have a DE3 clause in a policy with a relatively low deductible or excess in the policy, but you may also have a more favourable exclusion, maybe D4, D5, Leg 2, Leg 3. You could have a more favourable exclusion in the policy, and the policyholder can choose between which exclusion to apply to a particular loss. And invariably, you will, as a policyholder, be required to pay a higher deductible or higher excess if you are going to choose the more favourable defect exclusion. So maybe in terms of numbers, if you've got a loss which could be covered by D3, maybe you pay a £10,000 excess. If you've got a loss that could be covered by D5, maybe you're paying £150,000 or £250,000 excess. And it is quite common to mix and match defects exclusions from the different suites. So you might have D3 going alongside leg 2 or leg 3. Starting with D1, D2 and leg 1, I'm going to deal with these pretty briefly. They are so rare in construction insurance policies that we almost don't need to deal with them. D1 and leg 1 are outright defects exclusions, and DE2 excludes damage to property both that's in a defective condition and property that's not in a defective condition, but which relies on property that is in a defective condition for its support or stability. The only time I've actually seen a D1 or leg 1 exclusion in a CAR policy anytime recently was in relation to a policy that was covering specifically hurricane risk in the Caribbean. And it was on the basis that there was only one insurer in the Caribbean that was covering contract works for hurricane risks. And so that was effectively the single risk they were covering under this policy. But even then, even if you've got a policy that's specifically covering a single kind of risk, I would suggest that from the policyholder's perspective, it would make sense to have a second policy that, in that case, maybe excludes hurricane risks, but has a more generous D exclusion that you could rely on if you have a problem with the contract works that is in connection with a defect. So let's go to where the real action begins. And I'm going to start with D3 and D4. And D3 and D4 have a very close relationship with each other. And I would suggest that they basically do the same thing, but one is a little bit better than the other in a specific respect. And it's D4 that is better than DE3, and the respect in which it is better is divisibility. So to start with DE3, D3 excludes damage to property insured which is in a defective condition due to a defect in design, plan, specification, workmanship or materials. And for the moment, I'm going to focus on the words which is in a defective condition. E4 then excludes any component part or individual item of property insured which is defective. So I'm going to come back to the question of divisibility in a moment, but for the moment I'm just going to pause on the requirement for or the test for something being in a defective condition. And I would suggest that the wording that is used in D3 is clear and obvious. What you're looking at there is a condition, whereas the wording in D4 is slightly less clear and obvious, because what you're concerned with there is property insured, which is defective. And a feature of all of the DE clauses is that it is slightly unhelpful that the word defect is used in different contexts. So for instance, in D3, you have reference to something being in a defective condition. Also in D3, you have a reference to a defect in design. And then D4 and D5, which I'll come to later, the clauses talk about something which is defective. So to what extent does the use of the word defective in each of those phrases, to what extent is it the same, or to what extent should the word defective be regarded as something different? Well, as I say, under D3, the word in a defective condition, to me, the meaning of that is clear and obvious. The focus there is on the condition of the property. If you go a little further into the clause, though, you then have the phrase due to a defect in design. And for me, it's a little bit unfortunate that the word defect is used in that place, because when we're talking about a defect in design, plan, specification, materials, or workmanship, what we're really concerned about is an act, error, or omission. So effectively a mistake. So what the clause is concerned with is property which is in a defective condition due to a mistake. If we then come to D4 and we're looking at the words which is defective, the first question for us is whether the words which is defective are meaning something different to which is in a defective condition. And for me, D4 and D5, when they're talking about which is defective in design, plan, specification, materials, or workmanship, that phrasing is really mixing up two things. It's mixing up a condition and it's mixing up a cause. So if we go back to D3, you've got a reference to a condition, property which is in a defective condition. And then secondly and separately, you have a reference to a cause due to a, as I've suggested, mistake. So you could say defect in design, plan, specification, effectively a mistake. So a condition which is due to a mistake. And what D4 does is shorten the language, and instead of talking about which is in a defective condition due to a defect in design plan, it just uses the phrase property insured which is defective in design. My view is that in those respects, what D3 and D4 do is the same thing. In my view, there is not intended to be any difference in this part of the two clauses, and that what D4 is doing when it talks about which is defective is talking about property which is in a defective condition. And the way I get there is to focus on the words is defective. Is suggests we are focusing on something. There is an object to what we are looking at. And defective, to me, is referring to something that is a condition. So in relation to the question, is there a difference between property that's in a defective condition and property that's defective? I would say not. And I would say in that regard, D3 and D4 effectively do the same thing. So, and to look at the question of defects and damage, the suggestion that I put on the screen there is that when we're talking about defects and damage, we're really talking about apples and pears. We're not talking about things that you can properly compare with each other. So a defect is a condition, whereas damage is a happening. And you can show this by playing through a couple of different possibilities. If you have undefective property that then suffers damage, then that previously undefective property is now in a defective condition. On the other hand, you can have defective property that then suffers damage, which as a result becomes even more defective than it was before. And the point is that property being in a defective condition today really doesn't tell you anything at all about whether it has suffered damage in order to reach that condition. And for that reason, the question, is property defective or is it damaged, really makes no sense, because after suffering damage, property is always defective. And what you're really concerned about when you're looking at the defects exclusions is not, is the property in a defective condition today, but has it suffered damage in order to reach that point? So come back to the question of whether property is in a defective condition, which, as you recall, is what we're concerned about in order to work out whether DE3 and DE4 are going to exclude the damage that you're concerned about. I'm going to look at a couple of marginal cases and look at the difference very briefly between damage and physical damage triggers. So in CAR policies, your insuring clause will typically be triggered either by damage, or it could be triggered by physical damage. And in one sense, it doesn't really make it doesn't make intuitive sense for there to be a difference between those two phrases, because if you think back to the test for what constitutes damage, damage requires a change in physical condition. So how could you ever have a change in physical condition that is damage but not physical damage? Well, the reality is that the courts have grappled with the term damage and the term physical damage in a whole variety of cases. And what appears now to be clear is that damage and physical damage should properly be regarded as related concepts, but slightly different to each other. And damage can include transient and reversible changes in physical condition, whereas physical damage will only include permanent and irreversible changes in physical condition. So we can apply those two concepts to a fact pattern to try and work out the extent to which DE3 might exclude a particular adverse change in physical condition. So suppose we have some internal pipework in an office, and that pipework develops a biofilm on the internal surface. And you can see a picture of an example on your screen. And suppose that if the biofilm is removed, then the pipes are then in perfect condition. If, on the other hand, the biofilm isn't removed, then what will happen is that the pipes will suffer accelerated corrosion. So we've got pipework, biofilm develops, it's capable of being removed without any permanent or irreversible change in condition. But if it remains there, then there's going to be corrosion, which would be a permanent and irreversible change in condition. So, first question that I'm going to put to you, I've got 3 poll questions for you today, is if the policy is triggered by physical damage, is the property in a defective condition before the physical damage occurs? And I am launching the poll now. Just give it another moment, some answers coming through. The no's are looking very strong at the moment. It's up around 75%. I'm going to cut it off there and I'm going to share the results. Okay, so 75% of you say that if the policy is triggered by physical damage, then the property is not in a defective condition before the physical damage occurs. So let's take this step by step. So what is the physical damage in this scenario? The physical damage in this scenario is corrosion, because the development of the biofilm is a transient and reversible change in physical condition, as opposed to a permanent and irreversible change in physical condition. And before the corrosion occurs, the pipework has biofilm on the internal surface. And the presence of the biofilm on the internal surface means that the property is in a defective condition before the damage occurs. So policy is triggered by physical damage. It's the corrosion, not the development of the biofilm, that's a physical damage. So at the point that corrosion occurs, you've got the biofilm on the internal surface of the pipework, And so if you had a DE3 exclusion in a policy which was triggered by physical damage, then the corrosion would be excluded because the property would be defective, in a defective condition before the damage occurred. So I'm afraid I am siding with the minority here, and it's the 25% that I would suggest are correct on that point. Bear with me a second. I will get rid of the poll and then move on to the next slide. Okay, second question, very similar to this. If the policy is triggered by damage, so if the policy will respond to transient and reversible changes in physical condition, is the property in a defective condition before the damage occurs? And let's launch this one. Should be seeing the poll now. Similar kind of response by the looks of things. I'm going to leave it a moment, just see where it ends up. Okay, I'm going to leave it there. 63% say no and 38% say yes. I mean, that's really interesting because I do wonder if perhaps some of the answers have been coloured by what I said in relation to the first question, but the answer is that the no's are correct this time. So let's play it through. What is the damage? Well, if you've got a damage trigger in a policy, then the policy is going to respond to transient and reversible changes in physical condition. So there's damage before the corrosion happens in this scenario. The damage is the development of the biofilm itself. And before the biofilm lines the inner coating of the pipework is in perfectly good condition. And for that reason, the pipework isn't in a defective condition before the damage occurs. And so in this scenario, there would be cover under the policy. DE3 would not exclude this loss if the policy was triggered by damage, whereas it would exclude the loss if the policy was triggered by physical damage. Okay, so having worked out what the test is for whether property is in a defective condition, we then turn to the question of what the relevant property is. And the nature of the relevant property is really what is the difference between DE3 and DE4. And just as a reminder, what DE3 is concerned about is property insured, whereas when we come on to DE4, we are going to be talking about component part or individual item. And conceptually, it's not that straightforward to work out what the relevant property is in relation to DE3. And the best that the courts have done in relation to the question of divisibility is probably what the Court of Appeal said in the case of Seal Austria. And the main takeaway is what the court suggested is that in order to identify the relevant property, you're looking at a commercially separate and distinct part of the work. The full quote from Seal Austria is as follows: parts of the work which in commercial terms are to be regarded as separate and distinct from that part in which the defect exists. So parts of the work which in commercial terms are to be regarded as separate and distinct from the part in which the defect exists. Okay, well, what's the part? The Court of Appeal of New South Wales, in the case of Walker and Civil Engineering and Sun Alliance, has suggested that reference to part, the decision was not actually in relation to DE3, but it was in a sufficiently similar wording that it's been suggested that this decision is on point. said that part is not a reference to a part such as a tank or a gasket. It's a reference to a part of the work being carried out by the appellant. So I'll read that again. A part in this context is not a reference to a part such as a tank or a gasket. It's a reference to a part of the work being carried out by the appellant. So what that's looking at is, when we're looking at what is the commercially separate and distinct part of the work, we're not looking at a part of the physical property, but effectively a stage of the works. Now, that might be right, but my view is that an English court could easily come to a different view, so that effectively the difference between DE3 and DE4 is that it's concerned with the degree of divisibility of the physical property. And that's my view as to where the dividing line should properly fall in relation to DE3 and DE4, that in order to read them consistently with each other, you should, when you're looking at both clauses, be concerned with the degree of the divisibility of the physical property. And you can think about how that might play out in real life by thinking about let's think about the cheese grater. And I apologize to our Aon guests today. I'm going to use the cheese grater a couple of times, but in relation to the cheese grater, if you're talking about the legs of the cheese grater, which have got these bolts on the outside that you can see clearly, the relevant property, if you are concerned with D3, would be the whole of the legs. And if there's a problem with the bolts, the relevant property, so far as D4 is concerned, is just the bolts themselves and not the rest of the legs. And that seems to me to be a way that you can conceptually differentiate between D3 and D4 whilst looking at both clauses as effectively being part of a coherent series of clauses. D4, does it get easier to work out what the relevant property is? Unfortunately, not really. And there aren't any authorities in relation to what the relevant property is as far as D4 is concerned. And the two options that I have put on the screen on the slide are both from the really excellent book on constructional risks by Paul Reed QC. And for anyone that works with constructional risks policies, I couldn't recommend that text highly enough. So I'm going to have my third and last poll in relation to the question of D4. And let's just have a reminder that what we're concerned about with D4 is component, part, or individual item. For D4, what's the relevant property? Is it an item as delivered to site, or is it something that can be replaced without requiring the replacement of the larger structure or unit of what it forms a part? So, poll 3, launch. I'll leave it a few seconds to get your answers. And I will tell you as you are giving these answers that in my view, there is not a clear right or wrong about this. Really interesting to see where it's going. Really, really interesting. It is looking overwhelmingly like the audience is going for the second option. Okay, let's call it to a close there. So 83% of you think that the second option is the right one, and 17% of you think the first option is the right one. And I have to say, so I'm not sure if I could share that. Yeah, okay, I'll stop sharing now. Yeah, I have to say instinctively, I feel the same as the majority here. It feels to me as if the latter test is likely to be a more helpful test. And it's also consistent with what I was saying earlier in relation to D3 and D4 generally, which is that, primarily they are concerned with the divisibility of actual physical property. Okay, so if we've looked at the two most thorny issues in relation to D3 and D4, which are, is the property in a defective condition before the relevant physical change occurs? And secondly, how do you deal with the divisibility of the property? Once you've dealt with those two thorny questions, then where you get to is the relatively straightforward proposition that if the relevant property is defective, then you have no cover, even if it becomes damaged. So I'm not doing this as a poll. I think the answers to this would be, I mean, they're sufficiently clear that I don't think we would need to do it as a poll. So is there cover for damage sustained by defective property where the cause of the damage is unconnected to the defect? And the answer to that is a very clear no, and the point was considered and disposed of very neatly in the Court of Appeal decision in C.A. Blackwell, where the Court of Appeal said this. Said the cause of the loss or damage is irrelevant for D3, specifically looking at D3. The cause of the loss or damage is irrelevant. Provided the insurer can show the property was in a defective condition, the exclusion applies. So, if the works were in a defective condition when damaged, the exclusion would apply, even if the damage had been caused by a bomb falling onto it. So it doesn't matter whether the cause of the damage is connected with the way in which the property became defective in the first place. Really doesn't matter. You could have a bomb falling on defective property and you don't get cover. What about, on the other hand, is there cover for damage caused by failures, such as defective workmanship, if the property wasn't in a defective condition before the damage occurred? And the answer to that is yes, absolutely, absolutely. Because what we're talking about here is not really, we're not talking about damage caused by a defect, because as I said earlier, the reference to defect in design workmanship plan is really talking about a mistake. And so is there cover for damage caused by a mistake if the property wasn't in a defective condition before the damage occurred? Absolutely. So as far as D3 and D4 is concerned, you don't need to worry about causation at all. Leg two. Leg two. Right, really briefly, not the bit in yellow, which is what I'm going to deal with primarily, but I have to say that what's excluded under leg two before you get to the right back, for me, is a little bit of a muddle. So as I said at the outset, the real action in relation to leg two, D5 and leg three is the right back. That's what we're really concerned about. But just pausing briefly on what's excluded by leg two, what's excluded is costs rendered necessary by defects of workmanship design plan. Okay, so let's put the word mistakes back in as I was doing before. What's excluded is costs rendered necessary by mistakes. Well, to me, that suggests that there's a causation element to leg two. But then the exclusion also talks about the exclusion relating to property containing any of the said defects. So property containing any of the said defects, and that is clearly talking about a condition. So how do you marry those two seemingly inconsistent approaches up? Well, I think the answer must be that what the exclusionary part of leg two is concerned with is the condition. And if that wasn't right, then damage to undefective property could also be excluded by leg two, which seems to me just clearly is not the intention of leg two. But as I say, the point about leg two, in terms of practical significance, is the right back. So what gets written back? It's the bit that's highlighted in yellow on your screen. And what's written back is that cost which would have been incurred if replacement or rectification of the insured property had been put in hand immediately prior to the said damage. So I'll just go through that again. That cost which would have been incurred if replacement or rectification of the insured property had been put in hand immediately prior to the said damage. Again, these Aon guests, but we're going to suppose now that the cheese grater collapses. Luckily for all of us, the collapse happens in a post-pandemic world on either a Monday or a Friday, and so there was not a soul in the city, and so no one is injured. But building falls down. First scenario, the collapse is due to the bolts on the outside of the building not being tightened properly. So bolts have been highlighted on the screen in front of you. Now, leg 2, in that scenario, would exclude almost nothing, because in order to work out what leg 2 excludes, you go back and all you exclude is the cost to put right the defect before the damage occurred. So immediately before the damage occurred, before the building collapses, you realize that these bolts are not tightened properly, you go back and tighten the bolts. So the cost of going back and tightening the bolts is excluded by leg 2 in this scenario, and the entire cost of repairing the building, aside from that notional cost of tightening the bolts, is covered. On the other hand, leg 2 can be Mr. Scrooge. What if the collapse is due to a defect in the foundation? Well, in that situation, you think, well, had I discovered the defect immediately before the building collapsed, I might actually have to take down the building in order to fix the defect in the foundations and then rebuild it. So that cost might be almost exactly the same as the cost of rebuilding the collapsed building. And so in that scenario, because the fix to the defect was really not straightforward, the fix to the defect taken at the point immediately before the damage occurred, really not very straightforward, you are going to have almost nothing covered under leg 2. And leg 2, more than any of the other defect exclusions, I would suggest, is a real Jekyll and Hyde clause. That means it is great as an alternative, but it is terrible as a standalone. So I said at the start that you often have a choice as a policyholder as to which defects exclusion you apply. Any day of the week, I'd love to have leg 2 as an option in my CAR policy. What I do not want to have is a CAR policy that requires me only ever to apply leg 2, because it could be fabulously generous and it can be fabulously mean. D5 and leg 3. Good news is all damage repair costs are covered. We're not covering improvement costs because those are not cost to repair, but all damage repair costs are covered. Hooray, hooray. On the other hand, the cost of repairing defects is not covered. And remember, what we're talking about is if something is just defective, then it's not covered. If something is damaged and then as a result is defective, then it is covered. So some issues that arise in relation to the application of DE5 and leg 3. Mere manifestation of a defect and defects which get worse. I'm going to deal with those as a pair. I'm also going to deal as a pair with the issues of inherent vice and fortuity and the need for something extraneous. And then I'm going to come lastly to the question of improvement costs. Mere manifestation of a defect. So those of you that deal with CR policies and D5 and leg 3 in particular will probably hear this quoted at you with reasonable regularity. And in my view, the phrase is used by insurers very frequently in the wrong context. So what does manifest mean? The Oxford English Dictionary says that manifest means clear or obvious to the eye and something that becomes apparent through the appearance of symptoms. So what we're concerned with here, if something manifests, if a defect, if there's manifestation of a defect, it is something that goes from being not apparent to the eye to something that is apparent to the eye. And you can look at this in the context of latent and patent defects. So a latent defect is something that is not capable of being discovered with reasonable diligence, and a patent defect is something that is capable of being discovered with reasonable diligence. And again, go back to dictionary definition of latent. Latent is defined as of a quality or state existing but not yet developed or manifest, hidden or concealed. I'll say that again, of a quality or state existing but not yet developed or manifest, hidden or concealed. And that juxtaposition of developed or manifest is absolutely bang on point as far as I'm concerned, because developed or manifest are different concepts to each other. So discoverability is not going to be covered if you have something that's in a defective condition and something happens so that you are aware of that defect. You effectively have a latent defect becoming patent. That is not going to be covered. Whereas if what you're concerned with is impaired value or usefulness, then there is certainly the potential that that will be covered depending on the degree of impairment of the value or usefulness. And how can you show that? Well, you show it by looking at a couple of different cases. The first one is, again, a case that insurers are fond of quoting, and the second one is the case that the policyholders always go to, and those two cases are not inconsistent with each other. They line up properly if you look at them carefully in the cases of Skindia steamships and the New Keeler. And in Skindia steamships, it was concerned with the fracture of a shaft which was regarded by the court as not being damage, even though the fracture had occurred during the period of the policy. And the reason why the fracture of the shaft was not regarded as damage in that case is because the shaft was already in such a bad condition at the inception of the policy that it was already useless. And you can contrast that with the case of the New Keeler, which is a Court of Appeal judgment, and Skindia was only a first instance judgment. But the Court of Appeal in the New Keeler was concerned with an accommodation platform which at inception of the policy had defective welds around effectively the feet of an accommodation platform that was attaching the accommodation platform to the sea floor. And those welds had cracks in them, and the cracks got materially worse during the period of the policy. And the Court of Appeal in the New Keeler said that the worsening of those cracks did constitute damage. And the reason why there's a difference between the New Keeler and the Skindia is all to do with the impairment of the value or usefulness of the property. So if you have, what we're not concerned about is whether property was in an impaired condition at the start of the policy period. That actually doesn't matter to whether damage subsequently occurs. What we're concerned about is whether during the period of the policy there is a further material impairment. So if you have a situation like in Skindia, where the change in physical condition was not a material impairment because the property was already useless at the inception of the policy, that's not damage. If, on the other hand, in the New Keeler, you have at the start of the policy period impaired property, which has still got some use, and then it becomes materially less useful during the period of the policy, then that does constitute damage. I'm getting close to the end, so I'm just going to rattle through the final slides. Inherent vice. So what are we talking about when we're talking about inherent vice? We're talking about an expected internal quality which then acts in an expected way. And a classic case in relation to inherent vice in this context is the case on the screen there, but I would contrast inherent vice with defects in quite a specific way. So if inherent vice is an expected internal quality which acts in an expected way, then a defect is an unexpected and unwanted internal quality which then act in an expected way. Effect on deterioration is then what's so in terms of whether you get cover for inherent vice or defects, you look at the effect of those things on deterioration. So if you have a defect combined with ordinary use or action and material deterioration, then you have insured damage. If, on the other hand, you have inherent vice and ordinary action and then deterioration, you have no insured damage. If that wasn't right, then effectively D5 and legs 2 or 3 would be almost meaningless, and they would provide effectively the same cover as D3, which can't be right. So, is there the need for something extraneous? So this links to the question of fortuity, and fortuitous in this context means an event that occurs by chance, is not intended, and has an external rather than an internal cause. And the question is, in relation to the need for something extraneous, is the building in of a defect an external cause? And if not, do any of the defects exclusions provide cover where damage is caused by built-in defects? And I would suggest that the existence of a defect that you do not know about satisfies the need for an extraneous cause. If you have a patent defect that then acts in the way that you expect it to, then you don't meet the requirement for having something extraneous. But if you have a latent defect, if you have a defect which has been built in, then the combination of the fact that the defect has been built into the property and the fact that you do not know about it satisfies the requirement for something extraneous. And there is no authority, certainly no English authority, that suggests that if you meet the requirement for something extraneous in relation to building in of a defect that you don't know about, you then need something second, a second extraneous thing in order to trigger the policy. That just simply doesn't make sense. D5 and leg 3, improvement costs. So what D5 excludes is additional costs of improvement to the original. What leg 3 excludes is that cost incurred to improve the original. Question, do those two clauses approach improvement costs differently from each other? I could give an entire hour just on this question, but I'm going to deal with it in seconds. No, absolutely not. In my view, the two clauses do not approach improvement costs differently from each other. And if that's right, then the question becomes, how should improvement costs be calculated? And let's remember that with all exclusions, the burden of proof in establishing the exclusion applies is on the insurer. And so this is something for the insurer primarily to grapple with. But if, essentially, you've got a couple of different choices. Do you approach improvement costs simply as a mathematical formula? For instance, the overall difference in cost, or do you take a more nuanced approach? I would suggest that the answer is it cannot be a mathematical formula, because if it was intended that there should be a mathematical formula, there would have been nothing easier than to include a formula in D5 and leg 3, and that the right approach has to be a more nuanced approach. And I would suggest that that more nuanced approach should be one of two things depending on what situation you're in. It should either be a holistic approach, where you offset any savings which result from the improvements, or potentially item by item, so only taking into account items of work which constitute improvements. And I would say that the holistic approach is going to be appropriate where the improvement items have a knock-on effect on other items of work which themselves don't constitute an improvement. So where the improvement items have a knock-on effect on other items of work which don't constitute an improvement. And item by item would be the appropriate approach where the improvement items can be viewed entirely in isolation. And an example of that would be, for instance, if you are replacing silver taps with gold taps. So how then do you go through that approach? Well, again, you could have a whole session on just applying this to a whole different set of facts, but I would suggest that the approach that should be taken to identify what constitutes cost of improvement is you look at three things. The first thing you look at is, are any of the remedial works or any item of the remedial works different to the original works in any respect? So is it different? And then does that difference produce a tangible benefit as compared with the original work? So if it's no more beneficial, just doing something differently does not constitute an improvement. But if it's different and the item of work produces a tangible benefit, then is there a cost associated with the way in which the difference produces that benefit? And if there is a cost associated with that, then that will be what's excluded. I'm very grateful to you for lasting the course. I haven't left a huge amount of time for questions, but thank you for listening. And I am going to go to the Q&A and see if I can just fit in one or two questions before we go. Okay, so the first question is, with regards to your second poll, you mentioned it wouldn't be excluded by DE3. Why is that so? The defect is the damage, and hence it should be excluded. Okay, so just as a reminder, the second poll related to the pipework, which has a biofilm on it, which if left, would cause corrosion. And from memory, the second poll related to a CER policy which is triggered by damage. And the question here says the defect is the damage. And I just go back to what I'd said earlier in the talk. Defect and damage are not the same thing. When you're looking at something that's defective, you're looking at a condition. When you're looking at something in relation to whether it's been damaged, you're looking at a happening. So you're looking at apples and pears here. So damage can occur, and as a result of that damage, something is in a defective condition. So the fact that you're looking at the biofilm as being defective doesn't answer the question as to whether it's damage. So let's play it through the examples with physical damage triggers and damage triggers again. So with a physical damage trigger, the pipework isn't damaged because it's got biofilm on the inside of the pipework. The pipework becomes damaged only when there's corrosion, because physical damage requires a permanent and irreversible change in physical condition. On the other hand, where you have a damage trigger, because damage responds to transient and reversible changes in physical condition, the biofilm constitutes damage. And so in that situation, the biofilm is damage. And for that reason, because before the biofilm was on the pipework was in perfect condition, DE3 wouldn't exclude the cost of removing the biofilm, because prior to the biofilm being there, the pipework was absolutely fine. I hope that answers that question. The second one is, it would be good to touch upon the crossover between DE and PI with a couple of examples. I agree. I'm not going to be able to do that in the very short time we've got available, but I will take that away as a topic potentially to cover in a future session. But that's it in terms of the questions. So thank you very much for listening, and I will leave it there. Thank you.